Thank you, Kayla.
You're welcome.
Good afternoon. Welcome to the House Economic Matters Committee's hearing session. It is March the 23rd. It's 1:02, and we are going to get started. I believe we have enough members on for quorum. I would again ask everyone who is on to keep yourself muted until you've been asked to speak. And also I would ask that you leave the chat for the members only. Again, the chat button down there is for members only. Everyone else, I would ask to please refrain from using the chat. I believe we're going to start with Senate Bill 217. Is there anybody here from the
Yes.
Senate Finance Committee?
Chair Wilson, this is Tony Salazar, Commissioner of Financial Regulation. It was
sir.
a administration bill. If you don't mind, I can
Please.
do the presentation. Thank you. Good afternoon.
Thank you.
Vice Chair Crosby and distinguished committee members. For the record, I'm Tony Salazar, Commissioner of Financial Regulation, and I'm here to testify on SB 217. My testimony will be brief, and I request a favorable committee report on this bill, which passed the Senate by a vote of 45-1. The Office of the Commissioner of Financial Regulation strives to protect Maryland consumers through the operation of a modern financial regulatory system that promotes both respect for consumers and responsible business activity. We proposed SB 217 to clarify the law and enhance consumer protection in the areas of loan repayments. So SB 217 helps reach those goals because it's based on three principles. Number one, loan payments made in cash or by personal, cashier's, or certified check, or by an ACH debit from a consumer's account, which means the most common forms of loan payments must be accepted by lenders free of charge. That's a big change in the law. Other payment-related fees must be disclosed and can't be upcharged, and consumer lenders are prohibited from steering borrowers to costly payment methods. These principles and the consumer rights they represent are not currently found in Maryland law, and they haven't been provided to consumers by a recent Fourth Circuit Court decision, which was the one called Alexander versus Carrington Mortgage Services. So SB 217, with the amendments agreed upon by industry stakeholders and the Consumer Protection Division of the Maryland Attorney General's Office, clarifies the law, as I said, and it protects Maryland consumers from so-called convenience fees that are charged by some lenders. As I mentioned, it prohibits lenders from requiring borrowers to pay fees on the most common costs, and it requires the lenders to accept loan payments made by borrowers free of charge if they're done in accepted form of payments. And it only allows pass-through costs if lenders do want to make a charge and those charges are disclosed. So there's no upcharges or so-called convenience fees like the ones that were the subject of the Carrington case. The bill represents a consensus product with amendments that were made in the House. And in part, those amendments clarify that the bill is applicable prospectively, and it changes the effective date to January 1, 2023, to give industry stakeholders ample time to implement documentation and procedural changes. Overall, I believe SB 217 sets clear rules and contains consumer rights and safeguards that haven't been found under current Maryland law or as a result of the Carrington case. And it does so through provisions that are well calibrated and needed to protect Maryland consumers and prevent marketplace disruption. With that, I request a favorable committee report on SB 217, and I'm happy to answer any questions or provide additional information that the committee may request.
Thank you. See one question from Delegate Charkoudian.
Thank you, Mr. Chair. Thank you, Commissioner, for being here. I do have some questions and some concerns about this, and I just wonder if we could back up and talk about, I understand what the bill is doing as it relates to cash, check, ACH, but I want to talk about the examples of like, if I were to pay my mortgage with Venmo or PayPal or one of these other things, especially if I'm financially, tight going paycheck to paycheck, I just finally got the money in there, so I'm using that instead of one of these other methods. I think that's what the Carrington case is about. Is that right?
Now, Delegate, so Carrington dealt with so-called convenience fees. If you're a lender, if you're a borrower, and you are within a few days of making a payment, And now Carrington dealt in the mortgage area. This bill applies to any consumer loan, to be clear. But in the Carrington case, they dealt with convenience fees. If you're right about to come up on the first of the month and you can't make your payment, some lenders were letting borrowers make ACH or other types of payments that way and charging them fees ranging from $5 to $25.
Okay, so, but that was in violation of current Maryland law, right? That was already, because current Maryland law, as I understood it before this, said that those couldn't be charged unless they were explicitly approved in statute.
Well, so there was no current Maryland law on loan payment fees. There was the collection statute that talked about what could be collected. And that collection statute was interpreted up until the Carrington case, the opposite of the way you said. It went to the Fourth Circuit, and the Fourth Circuit looked at it and said, no, that's not the way it should be interpreted. It should be interpreted the way you said that it currently is.
Okay, so the way that I said it currently is that you, unless Maryland explicitly says, unless we explicitly say you can charge, then you can't, right?
Or it's in the loan documents.
Or it's in the loan documents.
Right. So under, yes.
Here's
under
my
Carrington.
concern.
Oh, okay, sure. Sorry.
My concern is that right now, without this bill, they can't, unless they put it in their loan documents, they can't charge a fee, and most loan documents don't have it. And so what this bill actually is doing is giving them a way to charge the fee. That's my concern. So I actually think this may be worse. But
Sure.
if we are going to do this, the second concern that I have is that a lot of times these fees, you say it's the cost, it's written in there as like the cost to process it, but restricting it to the cost to process it without a description of what gets in that cost, you can dump all kinds of overhead. And we've seen this with other fees that, that you go to get some service and then you need a photocopy of your medical record and you get charged $30 for that because it's the overhead that's tied to the person who needs to make that photocopy for you or what have you. And so my concern about, one, it seems like we're allowing a fee that up until now we haven't allowed. And two, in allowing it, our language is so broad, I'm not sure that this doesn't take us backwards from where we are right now. And so I'm wondering, there's a bunch of settlements that have come out of these lawsuits against companies doing this, Carrington aside. These settlements have led to loan processors saying they wouldn't charge any fees. Now this bill comes in. I think the lawyers on this committee can tell me, does this supersede those settlements? And now the folks who had settled in the lawsuits not to charge a fee now are going to start charging a fee because we're now allowing that. I'm worried about, I'll say it's unintended consequences, but I'm worried this actually makes things worse than they might be right now.
I understand that, but consider the state of the law now is not known unless you're a lawyer, because there is no law, just throwing it out there for consumers. So this helps put a law out that consumers can understand. Number two, the two effects. If this statute doesn't pass, lenders will be able to charge convenience fees in any amount they choose. All they'll need to do is go amend all their loan documents. So credit card companies that have a 30-day notice to put out notices to consumers, they'll be able to change their notices and put in a $25 convenience fee.
Let
Yes.
me ask one final question, and thank you, Mr. Chair, for the time. Would you be open to an amendment that either better defines what actual costs are or directs your office to better define what actual costs are? Because I do worry that the actual costs could be dividing an overhead of an entire office by the number of fees processed. You know what I'm saying?
Well, sure, but so the definition in the
I read it.
act says, right, that it's
Actual
the actual cost by
yeah,
the
okay.
person for the processing. So it's not for the thing. And our office has the ability to write regulations. So we would gladly do that because our intent is not to have anything more than, pennies charged.
Okay. I would rather require that you write the regs, but thank you. Thank you, Mr. Chair.
Thank you very much, Delegate Chi.
Thank you, Mr. Chair.
My comment, question is along the line of actually Delegate Chakudian's, which is I'm a little confused. I thought when I heard your testimony, it sounded like this is a move to protect consumer interests. But then when I looked through some testimonies, it seems like you now are allowing the lenders to charge fees that were not originally disclosed to consumers. And make it easier for them to pay by electronic means. So my question is, what problem are we trying to solve with this bill?
So right now, it is to eliminate upcharged convenience fees because consumers, like I mentioned before, without this bill, lenders can just change their loan documents and continue charging the same fees they were doing before, because the Carrington case said that you can charge fees that are permitted by law or in the loan documents. So if they change their loan documents, they can then do that. Our bill prohibits the charging of convenience fees, like was mentioned in the Carrington case, and it requires that the most commonly accepted forms of payment be accepted for free. If we don't change the law, what could happen is that lenders will simply stop allowing convenience payments and collect the late fees, which are typically higher. So we would be avoiding that outcome too. And this applies to all loans, so not just mortgages.
All right, well, I don't want to take up too much time, but the
Sure.
AG's office opposition, has this been addressed?
Yes, they were part of the amendments.
Okay,
We discussed it at the chair of the Finance Committee's request, and that's why it's a consensus bill. But I'm happy to talk offline too.
thank you.
Thank you, Delegate.
Seeing no other questions, we'll go to our second, Andrew Fulgenetti.
Andrew's from our office. He submitted the written testimony from our office,
Apologize.
Chair Wilson.
That concludes the bill hearing on Senate Bill 217. Next, we have Senate Bill
Thank you.
271. Senator Gazzone.
So my name is Chair Wilson, Vice Chair Crosby, members of the Economic Matters Committee. My name is Eric Benner, here on behalf of Senator Gazzone to introduce Senate Bill 271, Commercial Law Disposition of Abandoned Property Waiver of Penalties. This bill was requested by the Comptroller's Office, so I will defer to Robert Shearer from the Comptroller's Office to continue the introduction and any discussion.
Yes, good afternoon. My name is Robert Shear. I
Go
am
ahead, Mr.
the,
Shear.
yes, can you hear me?
Yes, go ahead, Mr. Shear.
Yes, thank you. I'm the Deputy Director of the Compliance Division within the Comptroller's Office who administers the Unclaimed Property Act. I would like to thank Chairman Wilson, Vice Chairman Crosby, and all the members of the committee for allowing me to testify and be heard on this matter. Also like to thank Chairman Gazzone for sponsoring this important legislation on behalf of the Comptroller's Office. Our office shares the performance of abandoned property audits with third-party vendors. These revenues that are collected by these vendors are remitted to the state immediately upon conclusion of the audit and available to Maryland residents immediately as well, so that Maryland residents can claim their funds of unclaimed property. It is the industry's practice for these vendors that conduct these audits not to collect penalties on audits. They have built up relationships with holders of abandoned property, and the simplicity and the finality offered by these vendors as part of the audit to forgo penalty collection is a standard industry practice. If our office had to bring the functionality of collecting the penalties in-house, the cost as well as the potential loss of revenue from the vendors would likely exceed the penalties that we would collect. Furthermore, if we had to send a separate penalty assessment notice to the holder of these abandoned property, it would likely interfere with the relationship between the vendor and the holder, and also between the vendor and the state. And this would impact our agency's ability to efficiently perform this function. Now, the request in the proposed legislation came out of an audit by the Office of Legislative Audit, who told us that we did not have the authority to waive penalty under the Title 17 of the Commercial Law Abandoned Property. The comptroller does have this authority under the Tax General Article 13-714 for the taxes that the comptroller administers, withholding, sales tax, income tax, etc. This bill would grant the comptroller the discretion to waive penalties for the holder of abandoned property in a manner that's consistent with the comptroller's existing authority for the other taxes that I mentioned. I respectfully request a favorable report for this Senate bill. Thank you for your time and consideration, and certainly can take questions at this point.
Seeing none. That concludes this hearing. Next, Senate Bill 175. I believe the first is Denise Conway.
Yes, and good afternoon, Chairman Wilson, Vice Chair Crosby, and committee members. I am Denise Conway, Executive Director of the Social Services Administration at the Maryland Department of Human Services. I thank you for the opportunity to share the merits of Senate Bill 175. With me today also is Greg Sessick, the Director of the Office of Adult Services, and he will assist with any questions. In 1995, the Gramm-Leach-Bliley Act became federal law and removed federal restrictions on financial institutions sharing confidential information with Adult Protective Services during an investigation of financial exploitation of vulnerable adults. This was a needed remedy as all national data trends demonstrate that financial exploitation of vulnerable adults is an expanding crisis in our communities. In 2012, the General Assembly granted the Department's Adult Protective Services Program the authority to investigate financial exploitation of vulnerable adults and expanded mandated reporters to include employees of financial institutions. While the 2012 legislation was an important first step, it did not address all of the barriers to working across disciplines to ensure that protection of vulnerable adults occurred. Senate Bill 175 will remove current barriers to accessing data needed to investigate allegations of financial exploitation of vulnerable adults. The bill addresses the need to share critical information as it relates to an issue that we often prefer not to discuss with anyone: finances. Everyone involved understands the right to privacy and self-determination, but the very nature of Adult Protective Services investigation is an indication of a concern for a vulnerable adult safety. For the following reasons, the department proposes the legislative remedy and welcomes a favorable response. First, it will synchronize existing state statutes regarding financial exploitation, investigations, and record sharing. It will permit APS financial institutions and law enforcement to work cooperatively to support vulnerable adults. And last, it will provide a holistic investigation process that may support the possibility of criminal findings when appropriate. I urge a favorable report from this committee, and I thank you for your time and consideration and welcome any questions you may have.
See no questions. Tammy Bresnahan. Is there a Ms. Bresnahan from ARP? Okay, Greg Sekis.
Mr. Sessick, he is from my office, and he is here to help with questions. He does not have oral testimony to provide.
Okay. How about Robert Inton? We have Jeffrey Myers.
Yes, Mr. Chair, I'm here.
Mr. Myers, go ahead.
Until 51 days ago, I was the principal counsel of the Maryland Department of Aging. I'm recently retired, but I helped get this bill introduced through the Department of Human Services, and I'm here to report that the Office of the Attorney General does support the bill. I talked to Hannibal Kemmerer yesterday, and the Attorney General's office is still behind the bill as it was slightly amended by the Senate. The bill exists because of a coalition called Project SAFE, Stop Adult Financial Exploitation. It's a coalition of private and government entities. Commissioner Salazar has been a very active member through the years. And we've done a lot of work, and you can find out more about Project SAFE on the Maryland Department of Aging's website. Last year, Project SAFE was working on putting together a uniform form that all the APS offices around the state could use when they're requesting information from banks or credit unions, other fiduciary institutions about people where they were investigating as possible victims of financial exploitation, seniors and people with disabilities. And we were working on this form. We didn't have a uniform form for the APS offices to use, but there was a national form that the National Association of Adult Protective Services had promulgated. So we took that form, started using it. And that national form was based on the fact that the federal Graham-Bleach-Lively Act had eliminated any kind of federal restrictions on sharing information in these kind of cases where these kind of investigations are ongoing. And so we thought, well, it'd just be easy to adopt this form for Maryland. But as we were working on it, we found out there are some Maryland statutes that create problems. And this bill eliminates those problems. And so I urge a favorable report from the committee.
Okay, seeing no questions there. Again, Tammy Bresnahan. Bob Eaton, are you here? All right, that ends the hearing on House or Senate Bill 175. And that ends our bill hearings for the day, colleagues. Thank you very much for joining. Have a wonderful